Good morning, sir.
Morning.
This morning we're going to hear from Mr. Ricolden.
Yeah.
Thank you.
If you'd like to stand.
I do solemnly,
Sincerely and truly,
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much. Can you give your full name, please?
Simon Dominic Ricolden.
Thank you very much. Mr. Ricolden, you appeared at the inquiry on the 29th of September last year, and you confirmed the truth of 3 witness statements. That's your first witness statement, second witness statement, and third witness statement. I'd just like to begin today by briefly taking you through your 4th, 5th, 6th, 7th, and 8th witness statements. The 4th has a URN of WITN 09890400 and is dated the 15th of May 2024. The 5th is WITN 09890500, dated the 3rd of September 2024. 6th is WITN 09890600, dated the 4th of September 2024. The 7th is WITN 09890700, dated the 4th of September 2024 as well. And the 8th is WITN 09890800, dated the 16th of October of 2024. Do you have copies of all of those witness statements in front of you?
I do.
Can you confirm that your signature appears on all of those statements?
I can.
Can you also confirm that those statements are true to the best of your knowledge and belief?
There are a couple of amendments that I would like to go through, if that's okay.
Thank you very much. Yes, please do take us through those amendments.
So in the 6th witness statement, if it's of help to the inquiry, there's a couple of acronyms which are incorrect. The first one in the Rule 956 6th witness statement is I referred to SEG as the Senior Executive Group, with apologies, that should have been the Strategic Executive Group. In the same statement, I referred to DBT, and this should have been defined as the Department for Business and Trade. Thirdly, I referred to DRP, and that should have been defined as the Dispute Resolution Procedure. And finally, in this witness statement, I refer to DRT, and that should have been defined as the Dispute Resolution Team. In my 7th witness statement, again, I refer to SEG as the Senior Executive Group, and with apologies, it should have been the Strategic Executive Group. And finally, under the 7th witness statement, I refer to DBT, and this should have been defined as a Department for Business and Trade. I hope those are acceptable.
Thank you very much. Subject to those, are those statements true to the best of your knowledge and belief?
They are.
Thank you very much. Those witness statements, those that haven't already been published, will be published on the inquiry's website shortly. You are the director of the Remediation Unit, which was previously known as the Historical Matters Business Unit. Is that correct?
That is correct.
And you've been in that position since the 10th of January 2022. Can you assist us with what you were doing prior to taking up that role?
I worked for NatWest, then became Royal Bank of Scotland, and then back to NatWest again for 33 years, doing a number of roles through junior management, senior management, and leadership within the Royal Bank of Scotland.
Thank you very much. And towards the end of your time, I think you've said that you were involved in compensation schemes of some sort. Is that correct?
Yes, in my latter years after the financial crisis in 2008, I was involved in 2 significant remediation programs. One was called Project Rosetta, which was the investigating the alleged mis-selling of sophisticated financial products such as swaps and collars and caps. And we had to investigate 30,500 trades to understand whether they were mis-sold, and if they were, then we'd had to compensate the clients accordingly. And the second program was called Project Sapphire, And that was actually came from a government report, the Tomlinson report, when the Royal Bank of Scotland was accused of deliberately taking businesses to the wall in order to free up their capital. And effectively make companies go bust to free up the capital. And we were charged to investigating those allegations and compensating accordingly. I was the operations director in both of those programs. Thank
you very much. I'd like to look at the work of your team and your unit. Could we please bring up onto screen poll 00460645? You've produced a slide addressing the various schemes that are currently running. Come on to screen in a moment. Thank you. So we see there at the top the remediation unit, and you've separated out those schemes that are directly run by your unit and those that are run by the Department for Business and Trade. Is that correct?
That is correct.
We see there on the left-hand side the Horizon Shortfall Scheme. That relates to those who were not part of the group litigation, but who have been impacted by matters relating to Horizon shortfalls.
Correct.
We then have the overturned convictions. I don't think it's called a scheme, it's just overturned convictions redress, is that correct?
Yes.
And it provides redress for those whose Horizon-related convictions have been overturned by the courts.
Correct.
You then have the suspension remuneration review. That involves repayment to postmasters who are suspended without pay. Is that correct?
That is correct.
Can you assist us with why those postmasters wouldn't be able to claim under the Horizon Shortfall Scheme, or how that is different to the Horizon Shortfall?
They might be able to claim under the Horizon Shortfall Scheme, and if they do, they get compensated accordingly. There are others who do not have a claim under Horizon Shortfall Scheme but were suspended, and therefore they are entitled to reimbursement of that pay that they should have got when they were suspended.
If you are a sub-postmaster who experienced a shortfall, but who was also suspended, do you have to complete two separate forms for those two different schemes?
No, you'll get your compensation through your address, through the Horizon Shortfall Scheme.
Thank you. And the suspension remuneration review therefore applies to those who didn't experience a shortfall but were nevertheless suspended, is
yes,
that
correct?
We then have the post office process review. Can you assist us with what that involves?
During our investigations for all schemes, a number of allegations, issues, complaints were received around a number of products, and the use of those products created what we call detriment. So we proactively did a review of a number of products where postmasters were identifying problems with them, i.e. detriment, and we investigated about 19 different products to understand whether or not the use of those products created detriment or potential detriment. That review of 19 products came down to 10, including an additional category called other. And we confirmed that those 10 products might or do create detriment. A good example of that would be a very bad training manual that was issued to a postmaster that had they followed that training manual to the letter, they would have suffered detriment. And therefore that it was believed should be redressed. And that is the scheme that is set up to redress those issues around those 10 products.
And do those products relate to Horizon in some way?
No, they don't.
Thank you. Can you give us some other examples, perhaps, just to assist us?
Might be a foreign exchange process. It might be an ATM shortfall not related to Horizon.
Thank you very much. And then there are two further schemes under your section schemes run by the Department for Business and Trade. The first is the GLO scheme. That's those who are part of the group litigation. Is that correct?
That's correct.
Presumably, your department or your unit is involved in disclosure, perhaps making representations as well in relation.
Just disclosure, we have completed the disclosure exercise required for the Department of Business and Trade for the GLO cohort.
Thank you. Are you able to assist us with when that disclosure was completed?
It was completed 4 weeks earlier than expected. I think it was around June of this year it was completed.
Thank you. And then the HCRS, the Horizon Compensation Redress Scheme, that is redress for those whose convictions have been automatically overturned by the recent statute. Is that correct?
Correct.
Again, your department provides information. What kind of information?
Disclosure.
What kind of disclosure might be required for that scheme?
Well, what we've done there, we've worked closely with government and with the and legal advisors about what disclosure they would require for these cases. Because many of these cases we understand, because it's obviously run by the Department of Business and Trade, their compensation may be limited to the £600,000 sum, and therefore the amount of disclosure to support those claims may be less, will be significantly less than for claims of over £600,000.
So is it likely that in relation to that scheme, it will be £600,000 as of right, without requiring more proof than simply that you were convicted?
Well, my understanding is that if the claim if the claimant is and their legal advisors are comfortable with an offer of £600,000, then limited disclosure, if any disclosure, is required to support that.
Thank you. Your team's work also involves other areas. It involves the criminal appeals review process, is that correct?
Correct.
And what is your involvement in that briefly?
I have ultimate oversight of it. The work is part of the remediation unit.
And is that providing, for example, disclosure to the courts or to the Crown Prosecution Service or others?
Via our legal advisors, yes.
Thank you. And also, I think your team is also involved in related civil liability, is that correct?
Correct.
And is that individuals who bring claims against the Post Office outside of those schemes, but relating to Horizon or more broadly?
Nothing outside these schemes or nothing outside Horizon, it won't be dealt with my team.
Thank you. At paragraph 140 of your sixth statement, you have outlined various meetings that you are involved in. Perhaps we could bring that up onto screen. It's your sixth statement. So that is WITN 09890600. It's page 42. Thank you. At page 42, paragraph 140, you've set out various other meetings and boards that you are a member of.
Yeah.
We have there A, monthly monitoring meetings with the Department for Business and Trade to formally oversee the historic shortfall scheme, discuss performance and any outstanding matters, risks and issues. We have the Horizon Redress Programme Board, the HMC. What's the HMC?
Horizon Management Committee.
The Horizon Management Committee or Horizon Matters?
Oh, sorry, Horizon Management Committee, yeah.
Thank you. If we scroll down to D, you chair two further subcommittees of the HMC. If we could carry on, please. The HSS DRP Decision Committee, can you assist us with what that is?
That's the dispute resolution process. That's a committee that oversees cases where we look at options available to us to resolve cases which might be going, as it says in the statement, that might be going to mediation.
Thank you. Monthly, previously fortnightly remediation committee meetings. And G, wider post office governance committees, including the weekly strategic executive group meetings. Do you feel that you have sufficient time for all of those and all of the other work that you carry out in your unit?
No,
And can you assist us with that, please?
there's a lot on. There's a lot to do. This is the biggest miscarriage of justice ever in UK history. That creates a lot of work. And I do spend a lot of time, appropriately, in my view, in governance forums, because I use those to make decisions and guide my business through extremely troubled times.
Do you feel that you have sufficient support, sufficient staff, sufficient deputies?
Yes.
And how long do you feel that you have had sufficient support for? Throughout your period?
Oh, in terms of support and the team around me, yes, I feel I've had adequate support for some time.
In her witness statement, and we've heard in oral evidence, Karen McEwen commented that the sheer volume of information and number of compensation schemes and their complexity made it difficult for you to explain to her all the relevant information. Is that something you agree with or disagree with?
Can you repeat that, please?
The sheer volume of information and the number of compensation schemes and their complexity made it difficult for you to explain to her all the relevant information in her original briefing.
I apologise if that has come across that way, and I didn't realise that that I hadn't explained it clearly enough to her. I think by their very nature, I think these are complicated. I think they are the right thing for the postmaster. Having said that, my experience would say they're not. From my experience of other remediation schemes, complexity is what they bring. And in order to ensure fair and reasonable outcomes in a timely fashion to postmasters, sometimes they will be complex.
Before we turn to the specific schemes, I want to ask you some broad questions about the administration of those schemes and some themes that have come up recently before we took the break in respect of their administration. First of all, has it been the view of the organisation throughout your involvement that the schemes should not be administered by the Post Office?
No, it has not been. I have a view, and I'm conscious of the evidence that Mr. Reid gave as well, which I, by the way, conform to, is when I was first interviewed for this role, which would have been in 2021, back end of 2021, I was interviewed for the role to head up what was then called the compensation schemes and now redress schemes. And I made it very clear to the interview panel that traditionally, whatever traditionally means, that you wouldn't run a remediation scheme this way. I was asked how you would run it, and I was clear in the interview that it would be completely independent of Post Office. It would probably be part of government, report into government, but there'll be a way that you could separate it. And there was a real danger of conflict of interests. And you know, it has to be separate from the Post Office because you're judge, jury, prosecution, witness, etc. The feedback I got directly from the chief executive was that they'd sort of been down that route and had a clear direction from government that there was a degree of accountability here in that the Post Office had committed these dreadful things, and by the way, some dreadful things have been done, and therefore it was sort of feet to the fire time, and you did it, you fix it. I can go on further and say, so you know, I think it's very clear as also from the operational agreement between the government and Post Office about how we operate the schemes. I think clauses 5 and 6 is very clear as well about that Post Office will be doing this, and Post Office signed up to that operational agreement. So from that point, the die was set, and there was probably little point in pushing against that because the agreement had been settled.
And what was the view of Mr. Reid as communicated to you about the appropriateness of the Post Office carrying out those schemes themselves or administering the schemes themselves?
Mr. Reid made it quite clear that he agreed with my point, and that he had said he had pressed government on this, but had the response, it's sort of feet to the fire time, and you're accountable, and therefore we are looking to you to deliver the solution. But obviously, the government will be extremely supportive and provide the important funding and all the governance and all the structure required in order for any redress schemes to be a success.
The inquiry held compensation hearings dating back to July 2022, April 2023. In your view, was that the articulated position of the Post Office?
Apologies, what was the articulated position?
Was the articulated position of the Post Office that it would have been better for the Department for Business and Trade to be administering and running those compensation schemes?
The articulated position of the Post Office was clearly embedded in the signed documentation under the operational agreement that this is how these schemes would be run.
And do you think that a picture was or was not given that the Post Office would prefer not to be administering those schemes?
I've seen evidence that it's clear that Post Office made their position clear to the minister at the time that the Post Office viewed it would be better and more independent, although it is independent. It will be clearer and have more transparency if government were to operate the redress schemes.
That's the articulated position to the minister.
Yeah.
You've been present at compensation hearings in this room. Do you think that that message has been articulated to the chair?
To Swin?
Yes.
In those compensation hearings, I don't think so.
And do you know a reason for that?
I think the reasons of that is, as I've said, and as I say in my statement, I think it's because the operational agreement made it clear which Post Office signed up to, that the Post Office would be administrating and carrying out the redress schemes. That was a commitment that they made. I have been in the Select Committee in February asked me this question as well. They asked me, they made the statement that in their view, the redress schemes operated by Post Office should be controlled by the government. I think the notes will show that I agreed with that. And the Minister at the time was in the room. And I know subsequent to that meeting, we had a ministers' meeting literally the next week when myself and officials from the department were mandated to go away and look at the opportunity and look at the possibility of transferring the Post Office redress schemes into government.
And what happened to that?
That was called, from a Post Office perspective, that was called Project Green. That's all documented. I'm sure in your evidence you've seen some of that articulation, and that was submitted to government. It would probably be March, April this year, and of how we thought that could happen. And at the time, the government declined the opportunity to pursue that any further.
Thank you. And has there been any change to that situation?
I think there has, yes.
To what extent and how?
In terms of over recent weeks, there has been some further engagement on that from the government.
And do you anticipate there will be a change to the situation?
Well, I think the interim chair was very clear about his intentions, his wishes in this space, and I know he's lobbied hard in government around that. So I do expect a change, yes.
Could we please bring up onto screen the witness statement of Mr. Staunton? It's WITN 114-10100. Thank you. If you could turn, please, to page 7. It's paragraph 14 I'd like to take you to. Mr. Staunton's written evidence and reflected in his oral evidence was as follows. He says, a few sentences down, as an outsider coming into the organisation with no prior experience of managing a company involved in the prosecution of criminal offences, it seemed obvious that exoneration was something that required proactive consideration. But it became clear early on that this was not on the agenda. Instead, there were 3 complex schemes for redress, which only helped those whose convictions had already been overturned or who had not been convicted but nonetheless lost money, for example, by ploughing their own savings into losses wrongly calculated by the Horizon IT system. These were administered, it seemed to me, in a bureaucratic and unsympathetic way, particularly in relation to overturned convictions, as evidenced by some of the examples given elsewhere in this document. Was that a view that Mr. Staunton communicated to you at all, that the schemes were administered in a bureaucratic and unsympathetic way?
No.
Did Mr. Staunton have a conversation with you at all where he was concerned that the post office wasn't getting it right in terms of the attitude to sub-postmasters?
No.
I'd like to take you to a couple more passages from his witness statement. Please, if we could turn to page 22. Do you have any views as to the sentence that I've just taken you to and your understanding of why Mr. Staunton may have said such a thing?
No. I had one conversation with the past chairman.
And what was said in that conversation?
It was a meeting that I established to brief him up on the redress schemes that the post office ran.
And did he raise any concerns?
He raised a lot of interest, but no concerns.
If we could please have a look at page 22, paragraph 41. He says at the bottom of that page, he says, my impression was that there seemed to be little recognition within the post office's remediation team that we were looking at an injustice on an industrial scale and that lawyers, both internal and external, made issues overly adversarial. That is why I suggested to Mr. Reid, while I was chairman, that the process be taken out of post office's hands. I'll take you to one more passage, 45A, that's at page 24. He says there, at my first board meeting on the 6th of December 2022, there was a discussion regarding postmaster repayments for unreconciled losses. We were told there were some 77 postmasters who were currently repaying unreconciled balances, despite advice that continuing to accept repayment where cases had not been investigated was a breach of an implied term in postmasters' contracts. There was a concern from the remediation team that if we notified postmasters and requested they pause payments, we might be inadvertently stimulating claims against an unfunded position. The board rightly felt that we should do what was right and pause repayments, but the fact that this was brought up at all indicated to me that the culture of the remediation team was to try to minimise claims. Again, were those concerns that were brought to you at all by Mr. Staunton or anyone acting on his behalf?
Absolutely not, no. It seems to me that the phrase inadvertently stimulating claims against an unfunded position, that is a risk that should be articulated in a number of different governance documents. So to your question, no, that wasn't. Mr. Staunton didn't talk to me about that.
Thank you. Could we please turn to poll 001-55397? What was your relationship like with Mr. Staunton?
Excellent.
If we scroll down, please. This is an email that the inquiry's already seen, and I'm sure you will have looked at it. Predates your time at the post office, and it's an email from Mark Underwood relating to the subject matter is GLO post-settlement group executive paper. And we see there at the bottom of that page, if we scroll down slightly, the section on fees, it's, as I say, something we've already looked at. He says there, my strong view is that you cannot seek payment from applicants, however small and regardless of the rationale behind it. Optically, this would be extremely challenging and would be in a position that I believe the business would struggle to maintain under political and media pressure. I think you can achieve the same desired outcome through having a very tight and clearly communicated set of eligibility criteria and requirements in terms of the documentation applicants have to provide in order to be accepted into the scheme. You weren't there at the time, but did you in any way have the impression when you joined that the schemes were set up to be intentionally bureaucratic?
No.
Do you have a view as to what is said there and whether in some way the eligibility criteria and requirements were too narrow?
I have a very strong view.
And what is your view?
That's outrageous.
What's outrageous?
To deliberately design eligibility criteria that will be restrictive. I think that's, in terms of remediation, you just don't go there. You just don't do that.
And having seen what you've seen over the number of years that you've been involved, do you have a view as to whether that plan was in fact the rationale or the something that was actually put in place?
In terms of what is in place, I don't recognise that.
In terms of what was in place on your arrival or before your arrival, do you recognise that at all?
No.
The inquiry has also seen a document from 2020 where Angela van der Boogaard suggests in 2020 that there were too many fingers in the pie from Herbert Smith Freehills and that in some way delayed the process. Do you have a view on that at all?
I don't know what fingers in the pie means. I think if the interpretation of that is confusing matters and elongating processes, I have to say, Herbert Smith helped design the process, and it's a very difficult process design to ensure full and fair redress in a timely way. So I think they were helping Post Office. So I think that's probably a bit unfair. And of course, all legal advisors have to be instructed, and they are instructed by the client. In this case, the client is Post Office. So I don't recognise fingers in the pie.
I won't bring it up onto screen, but just for the purpose of the transcript, that document is POL 002933169. How about Herbert Smith's involvement more broadly, given that they represented the Post Office in the group litigation towards the later stages? To what extent do you feel it was appropriate or inappropriate for them to design, for example, the HSS historic shortfall scheme?
So it was, their appointment was well before my appointment, so I wouldn't have had a say in that. And they are esteemed professionals in what they do. They've got a track record of being able to do build remediation schemes. I have no further comment than that.
Thank you. That document can come down. Thank you. I'd like to move on to the topic of taxpayers' money, value for money, and the Department for Business and Trade's funding. That's a topic that's cropped up quite a bit before we took our break. Could we please bring up on the screen POL 004584427? And if we could start, please, on page 2. This is an email chain discussing developments at the inquiry's hearing on compensation, Thursday, 27th of April. It's dated the 30th of April. If we look at the bottom of that page, we can see there some views from yourself. You say, indeed, in the appropriate spirit of collaboration on the basis of funds being no object, within reason, of course, I've asked that parties get together on Tuesday to look at ways the 32 weeks could be brought down. I think that's 32 weeks of disclosure in the GLO scheme, is that correct?
That is correct.
And the associated risks for Post Office Board would need to consider within and without appetite. This includes the potential for recruiting even more people. At that bullet point, you say, as briefly discussed with you both on Thursday, it appears that unless the contract being finalised between us on GLO disclosure is signed up by Wednesday this week, due to the Department for Business's identity change to DBT, this will be kicked down the road for a considerable amount of time, meaning Post Office will have to work at I think that must be at risk, for an unacceptable period of time. We see the phrase work at risk in a number of places. Does that describe a situation where the Post Office is having to fund these schemes without knowing, in fact, whether the government will step in and be funding them themselves?
In terms of the formality of the documentation, yes, correct.
If we scroll, please, to the first page and the bottom of the first page. We see there an email from Mr. Reid to Lorna Grattan, and he says as follows, about halfway through that email chain, he says, I always refer to David Bickerton's observation that no one will be criticised for paying too much compensation to postmasters. However, everyone will be slaughtered if we continue to nickel and dime on legal fees, admin costs, compensation itself, and a convoluted and complex process. See today's article in the Times. I won't allow this to happen, as my job is to protect the brand, ensure timely compensation is paid and speedy justice delivered, and that trust in the Post Office is not completely eroded through this torrid period. I hope we can work together on helping the Department for Business and Trade break the mould and understand that managing public money is not simply about limiting spend and reducing cost. It is also about the effective and efficient use of funds. I fear they're missing this vital ingredient. If we scroll up, we see a response from Mr. Staunton. He says there in the first paragraph, he says, no corporate would allow this to fester as much, which is why you're right to quote David Bickerton's observation that managing public money is only one ingredient of this exercise. And before I turn to a question, I'd just like to show you one other email chain, and that's between yourself and Mr. Cameron, and that can be found at poll 00423 And it's the second page, at the bottom of the first page into the second page, sorry. We see there, it's an email from yourself to Mr. Cameron, the 14th of May of last year. And you say there, I get the urgency that we really do need to get on with this as the clock is ticking. The judgment is pushing 4 years and victims of detriment are not getting younger. If it helps, we're paying away in detriment A with some momentum. A little further down, it says the funding request went into the Department for Business many months ago, has just been through DBT, is with Her Majesty's Treasury, His Majesty's Treasury, is due an additional governance layer and expected to emerge now July earliest, more likely September earliest due to the usual nonsense of summer breaks, etc. If you believe we should start communicating and settling prior to funding being formalised, better people than I can advise. But my understanding is a call for the Post Office Board, clearly with government representation, who are obliged to look at the interests of Post Office, to consider associated risks, including potentially wrongful trading, as the board would have to be comfortable that any liability would be covered by funding/support. But you know this, apologies. in terms of wrongful trading, was there a concern within the Post Office that because you hadn't secured government funding and were having to fund the schemes yourself, there may be an allegation or even an offence that's being committed by the Post Office?
Continually, for my entire tenure, this has been an issue about the potential for wrongful trading, and therefore, as a commercial, separate legal entity, the board have to act on behalf of Post Office, and therefore they have to be advised of the risks of potential wrongful trading. Therefore, without formal letters of comfort in place, as the lawyers would say, then that is a risk that the board will have to accept. And because the way the construct of the board is, there is potential personal liability there. And that's why they have to be appropriately legally advised about the risks of wrongful trading and the implications on the board, on the Post Office, and them as individuals.
Thank you. And if we scroll onto the first page, we see the response from Mr. Cameron. He says, in that context, our position on wrongful trading has changed in the business as usual business. We're delivering MBIT without sufficient funding and without thinking we're wrongful trading because of HMG policy, statement of intent, support letters, etc. Personally, I cannot distinguish the position from our position on remediation schemes. So it seems there was also a concern about wrongful trading in respect of the MBIT scheme.
Correct.
He says, I'm not saying, therefore, that we can rush off and do whatever we like, simply that the position is less clear-cut than we thought. But my main point is that the day after getting funding or deciding we cannot wait, we should be ready to progress all 14 work streams as appropriate with the postmaster community and be asking for any others at the same time. So it's clear to everyone we're pursuing justice with all the speed at our disposal. If that's the plan, great, but I don't get the sense that it is, and honestly, I think we'll come a cropper. He says, that is the point I would make at the board if I'm there, or you would be kind to make on my behalf. No criticism, no need to defend, just speed for the future, and if His Majesty's government doesn't like it, we need to have an argument. Thank you, that can come down. I'm going to take this in a number of parts. First of all, to what extent has, if any, has a focus on managing public money or value for money slowed down or impacted negatively on compensation? So the value for money or the managing public money aspect.
Well, I think there's a danger of two issues being conflated here. If I may answer that in maybe a slightly different way, and if it doesn't, please come back to me, is I don't think we should be confused about the amount available for redress and the impact of value for money on that, which in an operational sense I don't see any restrictions or value for money debate around the amount of redress available for payment. I want to make that clear. I know this is something that Sir Win asked a question of a previous witness about. So in terms of the £1.4 billion provision available for redress in the Post Office redress schemes, that is sacrosanct, and I don't recognise any value for money debate around that. And certainly the terms of references for the independent panel in HSS and the independent panel on the OC, there is no restriction in there about amounts, or there's no debate about value of money. There's nothing about this is taxpayers' funds at all. This is what is a fair and fulsome response to this in terms of the amount of redress. So I don't recognise a value for money debate in redress. Where I do recognise a value for money debate and officials reminding me and my team on a regular basis around that we need to manage public money appropriately, and there are plenty of green papers that say more about them than I can, then that is a consistent conversation with government, about, with me and others. But that's more around the process designed to release those redress funds. So is there a value for money debate challenging whether that is an appropriate process? Are there more efficient ways of doing it? Can you find cheaper lawyers, dare I say that in this forum, etc.? then that is a consistent challenge. Now, if that's a value for money debate, then I understand that. But it's not about the redress. It's more around the process established to release that redress. I hope I'm making some sense.
Yes, I mean, we saw in that email from Nick Reed, he said, we'll be slaughtered if we continue to nickel and dime on legal fees, admin costs, and then he said compensation itself.
Yeah.
Is it your view that when it comes to compensation itself, there is or is not consideration of managing public money, value for money, value for the taxpayer?
It is my strong view that there is not a value for money debate around the amount of redress that is paid out.
And in respect of the test that is applied when calculating an amount to be given to an individual, is there any consideration of that?
In terms of the independent panels, there is no reference to that for a consideration at all in their determinations.
I said we'll take it in stages, so that was the managing public money aspect. To what extent, if any, has the Department for Business and Trade delay in authorising or their bureaucracy slowed down or impacted negatively on compensation?
I don't know whether I can put a value on that. You know, the government have a process to follow in order to release funds to make processes available. And the process is the process in that the DBT, Department of Business and Trade, do not have oodles of cash, and nor should they, waiting for Post Office to apply to fund redress schemes. They have a process they need to go through. They need to see a business case to justify that spend. They need to analyse that. They need to understand that. And then they need to go to Treasury. They have their own process. It's absolutely tried and tested. My challenge around this has always been it's very difficult to articulate a process that nobody has ever done before. This is the biggest miscarriage of justice ever. And my frustration has been around the whole process, and government know this, you've seen all my emails, is that we're trying to squeeze a non-BAU process, in business as usual process, into a business as usual process. And this breaks the mould. As I keep on saying, this is the biggest miscarriage of justice ever. And to be restricted by a BAU, and there are good reasons for it, I'm not arguing against those. There are good reasons for it to make sure it's fit and proper and set up appropriately, understand that. But that can be restrictive. And that process takes months. And during that process, quite understandably and reasonably, you get lots of questions back around, don't understand how you get to that number. How do you justify that? Please explain this. And that's absolutely fine. You have to look at your business case for that. But that whole the process takes its time. It takes its time in terms of the process it needs to go through.
I mean, in that exchange with Mr. Cameron, for example, where you're discussing concerns about wrongful trading, concerns about the delay in funding and those kinds of matters, and that's 2023, that's the summer of 2023. To what extent have delays been built into the system because of that process?
Well, you never build any delay into a system. To be clear, what Mr. Cameron's talking about is redress schemes outside the terms of reference for this. My understanding is that these are schemes non-horizon related, but they follow the same process in terms of getting funding. So you call it delay. That was your word. I don't necessarily call it delay. I just say that's the process. That's the time it takes. But did it stop the launch of those programs until that was in place? Yes.
We heard suggestions from Mr. Staunton about needing to hobble up until after the next election in terms of compensation, the election that's recently happened. Was that something that was ever mentioned to you?
No.
From your experience, is that something that is likely or unlikely to have happened?
If I was asked to do it, I would be here.
So you were never asked to do it. Is it something that is likely to have happened or not, in your view?
That would be speculation. And I can't speculate. This is a public inquiry. I can't speculate. I think it's highly unlikely.
You have funding, I think you've said in your witness statement, committed to the 31st of March 2026. Is that correct?
Sorry, what is committed to 31st of March?
Funding from the government for the compensation schemes. Do you have a definitive period in which funding ends or funding has been agreed to? What is the current funding period?
Apologies, I do, but I can't recall it.
Are you able to say anything in respect of the amount of funds that has been recently announced as part of the budget?
Do you refer to the 1.8 billion?
Yes.
I can only assume, and it is an assumption, please, it is an assumption. I know nothing about it at all. I know what my provision is. I know my provision for the compensation schemes, the redress schemes that I look after in Post Office, the 4. I know the provision for that is 1.4 billion.
And is that going forward, or is that taking into account sums that have already been spent?
So I can help the inquiry if it helps.
Yes,
there
please.
as well. So that includes so far as of last week, across all the schemes that I operate, we have paid out in redress 302 million. We have now a financial projection of what that figure is going to look like going forward. And there is a clear acceleration in there. There's been acceleration, and I'm happy to share the numbers with the inquiry. There's been acceleration over the last 6 months, significant acceleration of those numbers. And by March 2025, there are a few caveats of traction from postmasters, etc. That 302 million will exceed 650 million by March 2025. Then in the financial year 25 to 26, we anticipate paying a further 500 million redress.
So looking at the sums that have recently been promised, do you think that there is sufficient funding to cover all of those schemes that we have been looking at already this morning?
I do.
Thank you. I'd like to turn then to the Horizon Shortfall Scheme, and I think we'll go probably beyond the first break, just focusing on the Horizon Shortfall Scheme. It was previously known as the Historical Shortfall Scheme. Can you assist us with why the name was changed and whose idea that was?
It was feedback. And I apologise to all the postmasters for it. It was feedback from Lord Arbuthnot, actually, when I met him and Lord Beamish. And he reminded me that the term historical was offensive to postmasters, because, as we know now, this is very much a live issue now, and it's not historical at all. And he, with clear direction, he suggested that I go and consider the word historical, and we just took it out of everywhere. And I apologise to the postmaster population for it.
Thank you. You've addressed this scheme in your 6th witness statement in particular, and I'll be taking you to references within your 6th statement. It was launched on the 1st of May 2020 following the group litigation and the conclusion of that. Is that correct?
Correct.
I'd like to look at the inquiry's YouGov survey, and that can be found at EXPG 607, and it's page 48 of that report. If we could scroll down, please, we see a chart there, figure 35, perceptions of applying to the scheme. these were answers given on a base of 1,483 current applicants or applicants to the historic shortfall scheme. And you can see there, in terms of understanding the scheme, there is a lot more red than there is purple. 47% net hard, found it hard understanding the scheme. In terms of completing the paperwork, again, a significant number who found it hard completing the paperwork. 26% there, very hard. What is your view about those figures?
Apologetic.
Do you understand them? Do they take you by surprise?
No, they don't take me by surprise, and I do understand them, and that's why we have completely redesigned the application form for the mail out that we've just started.
How recently has that taken place?
So that was a week and a half ago. We started. Well, this is all about the £75,000 fixed sum offer, and the last cohort of that population that we have now started to mass mail, and we started that a week and a half ago, and we are now ramping up the numbers in terms of that mass mail out, and we are going to be mailing 30,000 past and current postmasters with the opportunity to apply for the HSS scheme if they have not already.
And is it your evidence that the information in relation to that scheme and also the application forms itself have been simplified?
Absolutely.
Yes, thank you.
And they're also available online now as well.
I'd like to turn to eligibility for the HSS scheme. That's addressed in eligibility criteria. Perhaps we could bring those onto the screen. That's poll 00448-027. We have there the eligibility criteria. First, you must have or have previously had a contract directly with the Post Office. Second, your application must relate to shortfalls which arose in respect of the previous versions of Horizon. Third, if you're making an application on behalf of another person, you must be a legally appointed assignee, personal representative, attorney, or deputy of the person you're making an application on behalf of. Fourth, you must agree to be bound by the terms of reference for the scheme. Fifth, your application and time with the Post Office must not involve or relate to any criminal convictions. Six, you must not have been part of the group litigation against Post Office that settled in December 2019. Can we please return to your sixth witness statement? That's WITN 09890600 and page 52. Paragraph 159. Thank you. It's page 52, paragraph 159. You say at the top there, when compared to previous years, 2023 to 2024 has seen an increase in the number of applications being deemed ineligible, whilst the terms have been unchanged. And we see there that in a chart, if we scroll down slightly. So the increase, I think, that you're referring to can be seen by that blue line. Is that correct?
Yes.
And the blue line there has increased significantly in relation to non-represented applicants in 2024. Do you know, do you have any view as to why that might be?
I mean, it says in my paragraph 159, the data itself does not provide a clear explanation for this trend. But it's worth noting that the 2020 mailing was targeted in nature and intentionally excluded persons who fall outside of eligibility. So the mailing in 2020 was a lot more focused on people who we thought were eligible. Since then, it's been a lot wider, and therefore you would expect more to be ineligible.
Because, I mean, for example, we had the ITV drama in early 2024. Might there be some relationship between the number of ineligible claims there to have risen in early 2024?
I'm very grateful for the TV drama to raise interest. So the more volumes you get, then the more likelihood there will be cases that are eligible. Yes, that's logic.
But is that the likely explanation for that peak?
I wouldn't say that. The peak in activity absolutely is as a result of the ITV drama, but I'm not going to speculate about whether that's the reason for more eligible applications.
If we could scroll down, please, we can see the time that is taken. If we keep on scrolling on to the next page, page 53, there's a table there that sets out the days from application to eligibility, confirmed, split by legally represented and complainant complexity. It seems there from 2020 we can see, for example, those who were represented in complex cases in 2020, eligibility decisions took somewhere between 450 and 500 days to determine. Can you assist us with why it took so long?
The original focus will be on cases that we could get through more quickly because they were complex cases. We're conscious of time, and because they're complicated, they take more time to assess and for eligibility. They're more complex cases.
Does that simply reflect the fact that in 2020 there were a large number of claims being filed?
All cases,
applications being
yes.
filed? Yes. We don't see that in 2024. Is it possible that we might see that in a slightly later chart, or has that issue now been taken care of?
We try and learn our lessons. I hope it's clear to the inquiry. And the lesson there was that we needed the right resource in the right place. And that's what we did. We put the right resource in the right place. And therefore, I am hopeful that we continue with that modelling going forward. And therefore, we will have a better process, a more efficient process going forward. We have to take into account that the expectation in the HSS is that a significant portion of new claims coming in following the mass mail and following the exercises we're going through at the moment, a huge proportion of those will be under 75,000, and there is a completely different quasi-automated process around that, which will make the eligibility check and the payout a lot quicker.
Can you assist us with why it might be that eligibility decisions on represented applicants seem to take longer than for those who are not represented?
I don't know.
I mean, in 2020 and 2022 in particular, very significant differences between those who are not represented and represented. Can you give us any idea as to why that might be?
I would be speculating, and I'm not here to speculate. I think the legal advisors do a very good job in terms of ensuring that their clients apply for the appropriate levels of compensation.
But eligibility doesn't have anything to do with the level of compensation. No. So can you assist us with why it might take longer to process just simply the question of eligibility?
No, I can't.
If we look at the paragraph below, you say, of the 3,427 applications that have been completed, eligibility assessment on 31st of May 2024, there are 3,194, 93% confirmed as eligible and past the next stage of the process. If we scroll up and see that chart again, so you have a 93% current success rate in terms of eligibility. Is that likely also to have been the case earlier on? And if so, was there something going wrong that it took so many days to process applications that have such a high rate of eligible applications?
They took a long time to get through eligibility because the scheme hadn't started. Because although the scheme opened in May 2020, of course, we didn't have funding in place and the scheme didn't actually operate until after funding came in. So the clock would be ticking. So those checks would probably have not started happening until funding was put in place, which I think was March 2021.
But even in 2022, we see
Yes.
those two cases, the two charts, bars, that are between 250 and 300 days just to confirm eligibility. If you have such a high rate that are confirmed as eligible, why is it taking so long, or why was it taking so long to confirm eligibility?
That would be the result simply of volumes going through.
Of what, sorry?
Of volumes going through at the time.
But I think we saw that the peaks in volumes, or we will see, were quite early on and then again in 2024. I don't think 2022, for example, was a particularly busy year in terms of applications, was it?
No, but we were still dealing with the original cohort of 2,500 that came in, so they had to go down through the process. So in 20, given the funding was not in place until March 21, the scheme wasn't properly productive until the end of 2021. 2022 was effectively the year when most of the work was done. And if you look at the targeting that we delivered in 2022, you can see when the offers went out, and 94.5% of those offers were actually issued by the end of 2022.
Thank you. And if we look at 2024, on this chart, we can see that most I think the day, that's the average days from application to eligibility, it's over 50 days waiting for an eligibility decision. And if we see that below, it says that 93% confirmed as eligible. Might it not be easier or possible to design a quicker system given the high volume or high percentage that are confirmed as eligible? If overwhelmingly most are eligible, why must it take over 50 days to confirm that eligibility?
I don't think you can link the two. We are required for funding purposes to ensure they are eligible, so we have to go through a check. If the challenge is more around why does it take 50 days and can't you do it quicker, that is a fair challenge.
Yes, and what do you say to that challenge, and how can that be overcome?
And we have, as I said earlier, we have completely redesigned the process for the vast majority, our anticipation of the vast majority of claims of under 75,000, and the eligibility is a very much slicker and quicker process, and it will not take that amount of time.
If we could bring up onto screen your 8th witness statement.
Before we do that, Mr. Blake, this is just me being curious, if you like, Mr. Ricaldin, but in the year 2021, there appears to be no represented claimant, looking at the chart that we're currently looking at, which seems a little odd to me.
I think, if I may, Sewin, I think that might be down to the fact that we weren't taking any new ones in until it was confirmed that we were allowed to take in late applications. We effectively had the original cohort of 2,400 there waiting to be processed. They were submitted in 2020. 2021 was a year of building the scheme and getting funding in place, agreeing the principles and going through the governance. So effectively, I could understand why no applications would be, no represented would have been submitted during that period.
It looks as though at least some were submitted,
Yes,
but
somewhat,
not by those.
but not represented ones, yes, which is Sewin's point.
Yeah, all right, fine. I'll have to keep my curiosity in abeyance for a little while.
Could we please bring up onto screen your 8th witness statement? It's WITN 09890800. And if we could go to the chart, please, on page 4. Thank you. That sets out the number of applications that have been determined as eligible and ineligible. At the point of time of writing this witness statement, you had 373 applications determined ineligible. I think that has now risen to 397. Is that correct?
If that's the number I've submitted.
I can
Yes.
take you to the new. I'll take you to the new chart shortly.
Yes, if that's the number I've submitted, then that's fine, yes.
Yes. You've said in this statement or in the other statement that you can't say how many have challenged that decision. Is that correct?
Correct.
Are you able to give us an indication as to how many, whether it's a handful, tens, hundreds, or something else?
Handfuls, if any. I'm not aware of any. If there are, I would be made aware, and I'm not aware of many, but maybe a handful, no more than that.
So there are some that you are aware
Yeah.
of who have challenged that
Correct.
decision. Can you assist us with whether some or all of those were subsequently determined to be eligible?
I think all of them were.
And in terms of legal representation, were all of those cases involving individuals who are legally represented?
I don't know, but I don't think any of them were legally represented.
And can you assist us with what might have changed the situation regarding their eligibility? Was it about provision of more information or something else?
Yeah. Correct. They would have been asked for more information. They clarified a piece of information.
Thank you. That can come down. Thank you. One question is about branch assistants and branch managers. Why aren't they included? Why are they ineligible for the historic shortfall scheme?
Because they're not funded, because they're not included in the funding arrangements with government.
I'd like to take you to a number of documents addressing this, but when you say they're not funded, what is their redress?
So because they didn't have a direct, my understanding is they did not have a direct contract with Post Office, and therefore that excludes them from the HSS scheme. Now, I can only, my understanding of how things may happen and what I've seen happen is that if an assistant of a postmaster suffered a shortfall and as a result of that maybe dipped into their own savings or whatever they did in order to satisfy that, but kept the postmaster aware, and the postmaster was clear that that's what the assistant had to do, then that individual is not eligible to apply, but the postmaster has applied effectively on their behalf, and we have managed to resolve it that way. But from a formality of the scheme, those assistants are not eligible.
And can you see a problem with that?
Yes.
What do you see as the problem with that?
So I can see there are potentially assistants or postmasters who may have suffered, may have been forced in order to make good, and are still out of pocket effectively.
Can you also see an issue for sub-postmasters in that respect, that having received redress, they might themselves become the subject of litigation by those who work for them? If their only route of claim is via the sub-postmaster.
I am aware of that, but I'm only of that risk, but I'm only aware of 2 cases where that has actually happened.
And what has happened in those cases?
They've both been resolved satisfactorily directly with the postmaster.
Can you see a potential significant issue, therefore, for those sub-postmasters who had assistants and managers who themselves were out of pocket and who can't claim under the historic shortfall scheme or, it seems, any other scheme?
I have empathy and sympathy with that, and I can only assume that those considerations were made when the scheme was established. And
have there been efforts on behalf of the Post Office to try and change that situation?
There has been representation to government around that, and I know it's something the government are considering. and have considered in the past.
We'll go through the emails, or some of the emails. Has it been explicitly rejected in the past by government?
Yes.
And how much confidence do you have that that situation will change?
I know it is under consideration now. Government officials have advised me that it's under consideration by the Minister.
I'll take you then quickly through these documents because they may simply say what we've just been discussing, but we'll start with UKGI 000317750. This is a correspondence from September 2020 from Melanie Caulfield. If we scroll down, there's an exchange between the Post Office and the Department for Business. And she says as follows: I've not yet heard back from, I think that's Herbert Smith Freehills, but essentially it is only those with contracts with the Post Office who could potentially be held liable by the Post Office, not those they employed. And that is the justification for that limit. It says background: the scheme was open to people/companies who had or have direct contract with the Post Office, including multiples. It's only people with such contracts who would potentially have been held liable by Post Office for shortfalls. Assistants or postmasters or employees of other companies who had no contract with the Post Office would not therefore be eligible, i.e. they had no liability to Post Office. Claims in the scheme will be assessed by the Independent Advisory Panel using information available and in accordance with recognised legal principles. Line to take: postmasters and companies who had or have a direct contract with the Post Office and therefore could have been held liable for shortfalls were eligible for the scheme. Multiples were included and could apply. Claims can include consequential loss. Employees of other organisations with no direct contract with the Post Office would have had no liability to Post Office and would need to resolve any issue they had with their employer. And it's that final sentence, really, that seems to suggest that if a manager or an assistant of a postmaster suffered detriment as a result of shortfalls from Horizon, they would have to take that up with the sub-postmaster themselves. Is that correct?
That is. Would you mind just paging down, because I don't want there are two issues potentially being conflated here. You're absolutely right in that. But I think this email may be about what we call strategic partners, and sorry for the additional jargon, where we have strategic partners who run a number of post offices.
Yes, and that's something that I'll come to shortly.
Okay, that's fine.
If we stick at the moment with just managers and assistants, perhaps we could turn, please, to Bays 0001093. Can you assist us with what this is, the quarterly monitoring meeting?
It is what it is.
And who does that involve? That's
of
between the Department for Business and the Post.
Yeah, of course we can. This is an extremely important meeting, quarterly, as it says, that we're between the Post Office and government. It's chaired by government, by COL, Department of Business and Trade, and it's the sort of formal government overview, a shareholder overview of Post Office activity during that quarter.
Thank you. And this one took place on the 7th of September of last year. If we please turn to page 4. SR, I think, is a reference to you, and it says, SR also highlighted the Post Office had received the first claim where a postmaster had waived their right to a claim and assigned this to an assistant. You explained that a paper was due to go to HMC. Is that HMC can you assist us with HMC and the acronym there?
Horizon Matters Committee, the one I chair,
Thank
Horizon
you.
Matters Committee.
On this issue, as it would mean a change in the scheme terms of reference and eligibility criteria. Can you assist us? Was there a change to the terms of reference and eligibility criteria?
And my recollection is there was not.
Can you recall this case at all, or any like them, where a postmaster was able to assign their claim to an assistant?
I cannot.
Could we please turn to POL 00448861? We're now in March 2024, and this is a board meeting and a board report. Thank you very much. If we could please turn to page 43. Actually, if we turn to page 31 first, you can just see that it's a board report. No, sorry, 30, should be 31. If you perhaps go over the page. There we go. There's the board report, that's where it begins. And I'd like to ask you about paragraph 83, that's at page 43. It says there, late applications continue to come in, coupled with inquiries about the HSS from current and former postmasters, branch employees and strategic partners. For now, the Post Office continues to decline HSS applications from assistants/employees, since the HSS eligibility criteria requires applicants to have held a direct contract with the Post Office. So are we right to understand from those documents that we've just seen that in September of last year there was consideration given to changing the eligibility criteria in some way, but there has been no change?
Correct.
And if so, can you assist us with why there has not been a change?
The eligibility criteria hasn't been changed since it was originally established. The process of determining eligibility has become more efficient and will become more efficient, but the eligibility criteria have not changed.
And if you were a manager or an assistant, how would you know what your rights were or how to make a claim for the detriment that you had suffered?
You would seek, you could seek legal advice. You could go to the website to understand whether or not you will be eligible, and from there you would see that you were not eligible.
Yes.
Because you do not have a direct contract with the Post Office.
So how would you go about getting redress for a serious matter that's affected your life? Perhaps you lost your job, perhaps you lost your savings, perhaps you had to fill the till with your own money because there were shortfalls. How would you as a assistant or manager go about claiming any redress?
So I would go and speak to the postmaster who ultimately ran that and understand the situation from their perspective. And I might go and get legal advice.
Do you think it's fair to put that burden on the postmaster who may themselves have suffered shortfalls, whose lives may have been impacted?
The point is, yes, clearly. But they didn't have a contract with the Post Office, and the scheme is designed, it's clear that the eligibility criteria is that they had to have a contract with the Post Office. Their contract was with the postmaster.
Can I just clarify? When you said yes, clearly, do you mean it?
I have empathy to the situation that they thought, and I completely understand it and have empathy to that.
And going forwards, having discussed that today, do you think you would press for a change or not to the eligibility criteria, or for some other form of redress?
Ultimately, that's a decision for the for the government to make. The government provides the funding for the scheme.
But as somebody who is head of the unit that runs some of the schemes, for somebody who liaises with government as to funding, what is your position and what would be your communication to the government about those employees and those managers?
My position is completely understanding of the position those postmaster assistants find themselves in. I believe it's my personal view is that that I need to understand the risks associated with being able to open up that scheme wider in order to incorporate the significant number of people that might come in as a result of that. And some of them may have already been satisfied and some of them may not have been. And I think I've made it pretty clear to government what my view is, and I think that's one of the reasons, not my view, but I think these considerations is exactly what the Minister is currently considering.
I think you've said already in terms of the new funds that have been allocated that they will be sufficient. Do you have a view as to whether they would be sufficient if the schemes involved employees and managers?
So forgive me, I didn't say there were new funds. There have always been in existence, those funds.
The funds that were committed as part of the recent budget.
Correct. And my understanding, if the scheme was opened up to assistants and people without contracts directly with the Post Office, a significantly larger provision would be required.
Larger than has already been promised.
Correct. It's not promised. That provision has been delivered.
Thank you. So the announcement in the recent budget, that amount has already been delivered.
So I have known that funding for redress payments has been available for some time, and it changes as our modelling changes. As we get more experience with the schemes, we can anticipate with greater accuracy what those redress payments are going to look like across all 4 schemes. And we engage with government continuously on those projections, and therefore they adjust provisions, etc., along with the finance team, adjust accordingly. So forgive me, I don't want the inquiry to be under the impression that the 1.4 million has only recently just materialised. That this has been a number that has been growing, and was established some time ago, well before I came to Post Office. So the recognition of that redress has been in place many, many years.
Thank you. Are sub-postmasters told in any of your guidance or in any of your forms that they're able to claim in respect of redress for their managers or assistants?
I don't believe they are.
We've seen that 397 applications have been ruled or deemed to be ineligible. Can you assist us at all with a kind of proportion that might involve either, on the one hand, the employees and managers, or the, as you've said, the multiples?
No, I can't. I haven't got that split.
Is it rare? Is it common? More than half, less than half, that are ruled ineligible because they fall within this category of not having a direct contract?
I really don't know.
As you said, another issue and separate issue is issues that have been raised concerning multiples,
yes,
or those who have had licenses with somewhere like Costcutter or McCall's. Is that a correct understanding of that issue?
Should we call them strategic partners?
Yes.
Examples are McCall's, WH Smith's, Co-op, etc. And they have separate arrangements with the Post Office.
And they also fall outside the scheme, is that correct?
No, they don't. So
if you were an individual store that had a license from one of those organisations, they would fall outside the scheme, is that right?
So my understanding of the scheme, and McCall's is a great example, is that we do accept applications from the strategic partner, who coordinate the claims from all the branches post office branches they look after. And therefore we get one application in, and that is considered.
And
in the
have
scheme.
those applications come in? Are you aware of those applications being built up as we speak, or what is the current position?
So when the scheme was first launched, I know we had 2 strategic partners who came in, and my understanding is that those two that they have been resolved through the HSS mechanism, through the scheme. I now understand one other significant strategic partner is currently engaging with Post Office around a potential claim they have.
There are others who operated through corporate vehicles who also may not personally have a contractual relationship with the Post Office. Are you aware of an issue arising in relation to those circumstances?
No, if they're a corporate identity that might look after 10 or 15 branches, they can apply as their corporate identity, and it's similar with partnerships as well.
And what if there was, for example, a company that was the corporate vehicle for running the post office, but that has now been dissolved or went bankrupt, for example, it doesn't exist anymore? Is that possible?
Yes.
How about family members? Can they either claim in their own right or on behalf of their own family members? And if not, why not?
They're not eligible because they haven't got the direct contract in terms of family members. But in the case of an estate, for example, then they can apply on behalf for the estate.
If, for example, an applicant or somebody who wanted to apply but couldn't because of, say, dementia, or simply because they didn't want to apply themselves on their own behalf, is there a possibility that their family members can pursue it on their behalves?
Providing the appropriate powers of attorney, etc., are in place, there's absolutely.
Is there any plan? We've heard about current issues with the Horizon system. We've seen the results of our own survey in relation to those who still experience discrepancies, unexplained shortfalls on the current Horizon system. We saw the terms of reference there, and the eligibility criteria are based on the old systems. Is there any plan to put in place some sort of scheme addressing current issues with Horizon?
That is under consideration as we speak, yes.
Thank you very much. So that might be an appropriate moment to take our morning break, sorry.
Yeah, by all means, yeah.
Could we come back at let's say 11:47.
I think we'll extend to 11, Mr. Blake.
Thank you very much.
All right, fine.
Thank you, sir. Can you see and hear me?
Yes, thank you. Yeah.
Mr. Ricaldin, before we left off, we were discussing potentially extending the schemes to managers and assistants or others. And you said that you understood that to be a much larger figure. Is there a figure that has been discussed at all?
No.
Can
Excuse me, no.
approximate, in your view, what kind of ballpark we're talking about?
All I can not speculate. All I can say is that you logically look at a post office, you look at the postmaster, and then you look at the numbers of people they may employ to support them in that post office. And you look at that across the country, across 11,500 branches, and you do the maths. And that would be a considerable population.
And have there been discussions between the Post Office and the Department for Business and Trade or the Treasury about that potential?
I think they have, yes. But I don't think we put a number of potential redress on that.
And in terms of likelihood of there being some sort of change, is it likely or unlikely?
You don't need to speak to government about that. This is very much in the government's hands.
And how recently were those discussions with government?
My understanding that those considerations were being held at ministerial level a few weeks ago.
Thank you. So moving on from eligibility, providing that you meet the eligibility criteria, you're given the opportunity to seek repayment for any losses caused by any apparent shortfalls, and also not just the shortfalls themselves, but also consequential losses. Is that correct?
That is correct.
Thank you. Could we please turn to the consequential loss principles and guidance? That's UK GI 000-33420. Is it right to say that this guidance that's about to come up on screen was developed in the summer and autumn of 2020 and that it followed a request, I think you've said in your statement, from Hudgell's solicitors?
Correct.
If we scroll down, please, can you assist us with who developed these principles and guidance?
This would have been HSF with Post Office.
Thank you. If we scroll down, please, we see there a section on burden of proof, 3.1.2, if we scroll down, says, where the postmaster is unable to satisfy the burden of proof in relation to their claim may nonetheless be accepted in whole or part if the scheme considers it to be fair in all the circumstances. If we keep on scrolling down, there's a section that sets out established legal principles. If we keep on scrolling down to the bottom of page 3, we can see types of loss are outlined there. It says there's no exhaustive list, but it sets out, for example, loss of earnings. If we scroll down, loss of profits, loss of property, loss of opportunity, penalties, general or increased cost of financing, bankruptcy, insolvency. If we scroll down, legal and professional fees, stigma, damage to reputation, personal injury / harassment. Thank you very much. That can come down. In terms of categorization, you've outlined in your statements 3 types of cases. The first is something called below assessment threshold, or BAT. Can you assist us with what that is?
It's effectively a de minimis case, where if a case comes in where it's where the claim is below a certain amount, the operational cost of actually processing that would probably be restrictive, and therefore a decision was made that if a claim below a certain amount came in, we would automatically pay that amount.
And does that still exist?
That is now going to be superseded by the £75,000 opportunity.
Thank you. We'll get on to the 75,000 in due course. The second type of case is a standard claim, and the third is a complex claim. Can you assist us with the difference between a standard claim and a complex claim?
It's basically the number of heads of loss that are applied for in terms of the categorisation you've just gone through. So if it's 1 to 5, it will be a standard. If it's a 5 to 10, it will be a complex. over 10, I think, is a super complex.
Super complex.
Yes, extra complex, yes.
In your charts and graphs, you've only provided, I think, standard and complex.
Yeah.
Do those super complex fall?
Included in the complex, yeah.
Thank you. I'd like to look at the number of applicants and their current status. That is set out at paragraph 51 of your sixth statement. You said that when it launched, the Post Office wrote to 7,100 current and 20,000 former postmasters. And you also arranged for publications in newspapers. Is that correct?
That is.
Can we please bring up onto screen your sixth statement, page 49? So that's WITN 09890600. It's page 49. Thank you. Page 49. If we scroll down, please, we can see there a chart. And that sets out the applications received up until the 31st of May 2024 by date. And it shows there quite graphically two peaks, one in 2020 and one in 2024. We see there they effectively stop in between 2020 and the end of 2022, a very small number in 2021, and that might account for those figures that Sir Wynne pointed to earlier today in terms of the applications who were not represented. You've outlined the publicity when it launched. We know that the 2024 numbers occurred at a time after the ITV Mr. Bates drama. So that perhaps explains the peak. Is that your understanding of why
Correct.
it occurred again? Thank you. We know that, for example, phase 2 of this inquiry was in October to December of 2022. Do you think that that might have triggered some of those figures in late 2022, 2023? Or is there some other explanation for figures rising during that period?
So that's when we confirmed that we would accept late applications.
Thank you. Was there any publicity or anything done in the 2021 and early 2022 period to bring the schemes to people's attention, or did that stop altogether because of the cut-off dates?
We had formally, of course, we had actually closed, the scheme had closed in November 2020. So what we were doing, we were receiving applications that were coming in and we couldn't process them because they had missed the deadline effectively. So we wrote back to the people who were making these applications to saying, look, whether or not your claim will be accepted is in about, we don't know yet. So we're effectively putting them on hold. And then towards the end of 2022, we got permission from government not to reopen the scheme, but to allow late applications. So at that point we did, and we did publicise that via the website, etc., that we would now accept applications that were late. Originally, we did ask for them to describe why they were late, why they'd missed the deadline, and then that has vanished now. So now we just accept them as late applications.
Thank you. If we scroll over to page 50, please, you set out there the types of application. And we can see there in that table. Am I right to say that post-January there was a rise in the number of more complex cases?
Yes.
And can you assist us with why that may be, or what your understanding of that is?
I think people, I don't know why that may be, but I think people might be more educated around the scheme.
When you say People might be... What do you mean by that?
They might take an opportunity to look at the website to understand what they're entitled to claim for.
Thank you. I'm going to take you to the overall figures now. We can look at page 5 of your 6th witness statement, please. That's WITN 09890600. Thank you very much. If we could zoom out of that slightly to have all of the figures. Thank you. Is it possible also to bring onto screen, please, POL 00460646? Okay, that can't be brought up onto screen at the same time. Perhaps if you could have to hand your most recent figures, do you have those in front of you?
Yeah, let me just, if I may. Are these the ones I submitted on Friday?
Yes.
Yes, I have them.
Thank you very much. So we start there with applications received and logged. The figure as at May 24 was 4,323. Can you assist us with what the figure is now?
4,971.
Thank you. Eligibility work in progress, it was 896. Can you assist us with what it is now?
307.
Thank you. So a significant decrease in eligibility work in progress.
Correct.
Applications ineligible, I think we've already covered that today. That's now 397. Is that correct?
Correct. Which is 9%.
Thank you very much. Applications eligible?
4267.
Thank you very much. Offers sent?
2792.
No response to offer?
123.
Applicant in contact / querying?
9.
So a much smaller number of applicant in contact / querying.
Correct.
Disputes?
319.
Thank you very much. Can you assist us with approximately, if you're able to, how many or what kind of a percentage of those disputes involve individuals who are legally represented? It doesn't have to be an exact figure, but if we see there that the number of disputes currently is 319, can you approximate what kind of a percentage of those figures might be legally represented?
What I can help the inquiry with is the cases that are in our dispute resolution process. I am aware that I think the number is 70% are legally represented.
Thank you. And is that different to your categorisation of disputes here, and if so, why?
I don't think it is.
No. So about 70% are legally represented. Thank you very much. Offers accepted, you have there 2,248.
2,341.
Thank you very much. Again, are you able to assist with the kind of percentage that are legally represented? Is it the same or is it a different type of figure for those?
Legal representation across the entire HSS population is approximately the same. It's something like 12%. So legal representation across the total cohort is relatively modest. And yet the acceptance rate is now 84%.
84% who are...
Of offers, 84% of offers that are issued are accepted.
And of those, what kind of percentage are legally represented so far as you're able to?
I understand it's circa 10%.
Thank you. Settlements, 2,085.
2321.
Thank you very much. Total settlement figure?
118.5.
Thank you very much. Tax top-ups to HSS applicants?
14.8.
Thank you. Combined total paid?
230.1.
Thank you. We'll go through all of the charts that you have provided in your witness statement, or most of those charts, but can you assist us, in your view, what the differences in those figures, in your mind, shows?
if I may.
Yes.
Thank you. The one I would like, because when I got these rule 9s, it was very much asking me about trends
Yes.
and patterns, and hopefully I can help the inquiry here. So if you look at the statement that's on the screen, you look at the combined payout of 121. If you then go down to the notes, so that 121 was at the end of May 2024. If you go down to the notes, you can see on the 22nd of August that 121 had turned to 139. And that's a difference of, rounding, that's a difference of about 18 million. So in those 3 months, in terms of redress on this HSS scheme, there was £18 million paid out. The number I've just quoted, as at the end of October, is 230 million. So the difference between the 139 and 230 is fairly significant. And I think what that does is, so what's that? That's about 90 million. Now that is over a period from August to the end of October. So that's a 2-month period. So if you compare the 18 million over 3 months and the 90 million over 2 months, I think what it illustrates is a rapid acceleration of redress. And that, of course, is purposeful because we need to speed this up and we need to accelerate redress. So that is a major trend I would like to use this opportunity to point out to the inquiry in terms of the acceleration of redress. And I go back to a previous statement I made this morning that we expect over across all the schemes is now 302 million redress, and we expect that to be over 650 million by March 2025.
And what do you see as the principal reason behind a speeding up of redress in that period?
That'll be a more efficiencies and a better process, but predominantly because of the £75,000 scheme, which I know you want to talk about later.
Absolutely. So let's look at the average time it takes from eligibility to a decision. That's at paragraph 64 of the same statement. If we could turn to page 22, please. Thank you. So paragraph 64, you say for all non-BAT claims, so those are the standard claims and the complex claims, from the eligibility confirmation letter being issued, it takes an average of 470 days to an offer letter being issued. In respect of complex claims, this process takes an average of 514 days, improving to 306 days in 2024, although we note a lower volume of offers were issued in 2024. Can you assist us in reference to days there? In some places in your statement you refer to working days, in others just days. Are you aware of whether that is working days or all days?
Apologies, it should be working days.
Working days. For standard claims, this process takes an average of 445 days, and the data shows that this has decreased in 2024, with standard claims now taking an average of 302 days. So an average case took 470 working days. It's now decreased, but we're still talking very significant time periods, aren't we?
Yes.
What do you see as the principal reason for such delays? I mean, we're well over a year for an average claim.
The 445 you refer to.
Well, those are only working days, so if we include weekends, even more.
So they're not necessarily delays, and whatever I say, please, I don't want to be taken as defensive at all, because it's not. This process takes too long. Full stop. It does take too long. However, there is a process that has to be gone through, and that's all defined and all operationally agreed and all signed off. Could it be quicker and could it be more efficient? Yes, and that's what we try to do continuously, and we will continue to do that. So and those days will include what I call lapse time. So when it's queuing, so when a case is queuing for the next shortfall analysis to be done, or the next case assessor to be ready to. So there will be queues at each particular process point, and those days will include those. So this is not a true end-to-end picture. This is a reality picture, because this is what the postmaster is experiencing. So I'm not going to say, well, actually, because it only takes 2 days in legal review and 3 days in the SFA, that's a 5-day. No, it's when it's queuing, you have to include those days. The process is too long.
We see that there has been an improvement, and I think some of the explanation within your statement is that for the early claims, there were delays in, you don't call them delays, but I will continue to call them delays, relating to funding from the Department for Business and Trade. To what extent did those slow down the process from eligibility confirmation to the final offer being issued in those early claims?
Well, of course it did, because so to take, if I may add some colour to the whole thing and take a step back, everybody in this room will understand that the HSS was actually created from the GLO settlement agreement in terms of a scheme to compensate those not represented in the GLO. And that was the effectively activation dates. It was May 2020 when the whole thing started. But the scheme might have been announced and might have been started, but as with many schemes, including the recent appeal scheme announced by the government, it's just words on a piece of paper. There's no process, there's no anything behind it, there's no application behind it. So from May 2020, you've got to start building something, and that's exactly what was happening. And initially, the view was thought that the initial view was that a number of claims would be relatively modest, and we're talking about a few hundred. And therefore, an engine was built accordingly. And then as soon as the volume started coming in and mounting up to 2,500 applications, is that point I said, well, actually, that engine is not going to be appropriate anymore. And by the way, Post Office haven't got those sort of funds to be able to support that, and therefore we have to go to government and ask for it. And that starts the whole process around applying for funding.
Can you assist us with who was responsible for underestimating the number of potential applicants?
No, I can't. I before my time, and I don't know who would have been. I know there was a predecessor to myself who was appointed, but I understand that individual wasn't around for about 8 months before I started. So I don't know who that would have been.
Was there anybody in your role in that 8-month period?
Not that I understand, no.
I'd like to take you through the various stages of the application process and the offer process, unless you have anything else to say at this stage.
What I would say is, please, and to help the inquiry in the colour, and please, again, it's not. Please do not take this as be defensive at all. But the whole engine to be produced has to go through a huge governance process. So you talked about the consequential loss principles and you brought them up on the screen. And forgive me, I did say HSF and Post Office built those. But of course the panel, the independent panel, were heavily involved in their creation as well, which helps from the independence perspective. That whole engine in creating all those principles, creating the funding, creating the process to build, to make cases, allow cases to flow, took a considerable amount of time. And everything has to be agreed not only through Post Office, appropriate Post Office governance, but also government governance all the way through to Treasury, because at the end of the day, every process costs money.
Thank you. So moving on to the various stages, we'll start with the shortfall analysis stage.
Yep.
That process includes assessing or analysing whether a shortfall occurred and how much it's valued at. Who carries that out?
So my operational team carry that out, and how the process works is a postmaster in their application form will identify a time period when they thought they had a shortfall. The operational team, my understanding, I'm not an operator myself, when I say is that individual will go into the system, into the Horizon system, and they are aware, they have experience of the Horizons, and therefore they know what they're looking for. Some of these members of staff have been counter clerks previously at post offices, so they have sophisticated knowledge of the Horizon system and how to look for these shortfalls. So they go into the date where the postmaster has identified, and they look 6 months before and 6 months after that particular date to look for that shortfall and identify that shortfall. And they have the skill sets to be able to identify that, but also to be able to identify whether or not that was an Horizon shortfall or another type of shortfall. If there's any doubt, the default is that it is a Horizon shortfall.
And we've heard throughout this inquiry about different types of data being available to the Post Office. We've heard about ARQ data, for example. What kind of data is it that they are accessing?
So they are accessing Horizon data, and they're accessing a number of other data sources. And if they want even further to go and get a branch file, they can go and get the branch file as well to be assured of a shortfall.
But when you refer to Horizon data, do you know what that means? Do you know what kind of
Entries. So that they can look at the physical entries.
From where?
From at the time. So when the postmaster said it was the 24th of July, in whatever year, they can go in and look at the entries on those dates. But they recognise that the postmaster, that may be a guess at the date, and therefore they go in 6 months after. So they look at the whole year, 6 months after, to look for those entries.
And is that data provided by Fujitsu? Is that data from the Post Office's own archives or records?
So that will be Post Office, and some of that will be supported by Fujitsu.
You've said in your statement there's a low evidential bar. What do you mean by that?
In a language that maybe I understand better than most, is that if the postmaster says it happened, it happened.
That seems like no evidential bar.
No, it is. It is because, and this is a panel thing. This is an independent panel thing. Cases go to the panel where we cannot find a shortfall. So it goes through the FSA process, and the postmaster have said, look, there were 5 occasions, and here are the dates, and we've looked 6 months after and 6 months before, where we looked at it all, and we always go to panel and say, we can't find it, we can't find anything. The panel then will go to the statements and all other evidence that has been coordinated by the case assessor, and they will look at it in the round and said, okay, we can't find any actual SFA technical evidence, but in the round, do we believe, given all that evidence and the file, do we believe a shortfall may have happened?
Thank you. And we're used to legal terms, balance of probabilities, reasonable doubt, prima facie case, credible evidence. Are any of those kind of legal terms used in the shortfall analysis stage?
In the shortfall analysis, is those, yes, in terms of the mindset of the individuals, they're looking to be positive about it. Is it formally in their terms of reference for operating what they're doing? No, it's not. But they are a bit like, as I said, the default is it is a Horizon shortfall if they can't find another reason. So it's an empathetic, sympathetic approach. They are looking for the shortfall. They're not looking not to find the shortfall.
And looking forward to the ultimate offer, is it the case that the actual offers are in any way reduced because of the uncertainty at that particular shortfall analysis stage?
I believe not, no. The shortfall is just the trigger. It's just the trigger for the consequences of that shortfall.
So it won't be that because of a form of words that's used at that shortfall analysis stage about the certainty or uncertainty of the shortfall, that is then used at the offer stage to reduce or
That's not my understanding.
Can we please turn to page 58 of your sixth witness statement? So the same witness statement, please, page 58. This is the average number of days it takes for that shortfall analysis to take place. We see there on the bar charts, the average number of calendar days was significantly higher in 2021 and 2022. Is that correct?
Yes.
But we do also see from the volume that reflects albeit with a time lag, the volume of applications.
Yep.
Now, what we saw in the chart earlier is that after the Bates drama, there was again a second spike in those applications. We saw it earlier and then again in 2024. Does that not mean, and we see perhaps some effect of it there on the far right-hand side, that there's going to be another spike in volume because they have to go through the eligibility stage first, so there'll be an inevitable time lag. Will we not see a repeat of what we saw in 2021, 2022 later this year or early next year?
And later this year because of the mailing?
Because of the January 2024 and onwards spike in the volume of applications.
You will see that spike, yes.
And we'll see that in the number of calendar days that it takes for the shortfall analysis to take place.
So I hope not. I think there will be a spike, but we are busy as we speak of making sure appropriate resourcing is in place to avoid peaks in terms of longevity of timing and eligibility. In addition, as the interim chair said in his statement, we are looking at some automisation and efficiencies in this space as well in order to speed that process up significantly.
Can you assist us with quite what's meant by that in terms of automation?
I can. Firstly, there's the automation of actual payments that we have already improved on, and we will continue to do that. And secondly, and it is related, forgive me for jumping your agenda, it is related to the £75,000 process, where we have talked about the SFA process. With the £75,000, we are not intending to do an SFA. We're effectively doing a shorter version of it, and we're calling it an SFI for future reference. And that's all been approved through governance, etc., for the £75,000 cohort, which we believe will be the vast majority of cases. And the big difference between the SFA and the SFI in terms of efficiency is that you're only looking for one shortfall. Under the SFA, if the postmaster is saying, I had 6, you look at all 6, you look at 6 months before, you look at 6 months after, you draw up your report, etc., etc. On the SFI, it's when you find a shortfall. And at that point, for all cases under 75,000, we will not be doing a review with HSF. So Post Office are going to be entirely doing that process.
So to clarify, and we will get to the 75,000, but you're not granted 75,000 just on fulfilling the eligibility criteria. You have to have the eligibility criteria plus a shortfall. Is that right?
Correct.
Thank you. And you've spoken about increased resourcing. Can you assist us briefly with how you are preparing for a spike later this year, early next year, and into next year?
Hiring people.
Can you give us an indication of numbers before, after?
So I know we're currently in the process of hiring a further 20 individuals.
Okay. And when do you anticipate that will be completed?
My understanding is that will complete the hiring.
When, sorry?
Oh, so apologies. When? They're being hired now. So within the next few weeks, they should be in place.
Thank you. The next stage is the legal case assessment. Am I right to understand that a case assessor from Herbert Smith Freehills will compile a pack which includes their own assessment and analysis of the claim, which is then passed to the independent panel to consider?
I'm not quite sure whether it's an assessment. They coordinate the information they have. They get the SFA analysis, and then they do a legal review of the case, building the case on per heads of loss for consequential loss. The shortfall is the trigger, and they look at the claim and they assess, right, that claim means it's that consequential loss, and therefore I'll build the case around that. And what under each heads of loss, the assessor then outlines what the options to the panel could be for consideration under each heads of loss. So there might be 3 options under each heads of loss that the panel might want to consider. They're not guided to take those options, but it's things for their consideration. Once that pack is completed, that goes off into the independent panel.
Can you assist us with who at Herbert Smith is carrying this out? Is it junior solicitors, paralegals, partners?
A range, not partners, but a range of Herbert Smith appointees.
And do you have a view as to whether it's appropriate for Herbert Smith to be involved in this process, given their involvement in the group litigation, as we discussed earlier?
I think that the two are completely separate.
Do you know of any overlap of individuals involved, for example, in that process?
No.
Could we please turn over the page, please, to page 59? We see there the average days from starting legal case analysis to the offering, the issuance of an offer. And again, we see perhaps an increase in time, increase in number of calendar days it takes as a result of higher case volumes that have reached that stage from late 2021 into 2022. So again, are we likely to be seeing a spike late 2024 into 2025 because of higher volumes? And if so, at the legal case assessment stage, how are you going to avoid that?
I hope not, because as previously described, the anticipation is on the existing cohort that are going through the process, and indeed future cohorts, the vast majority will be under 75,000 and therefore will not be subject to a legal case analysis.
Thank you. Moving on to the request for further information. During this process, Herbert Smith Freehills, the case assessor, might issue a request for further information, or they might request multiple requests for further information. Is that correct?
Correct.
Can you briefly describe what that involves?
That is designed to help the postmaster's application. It's not designed to hold it up, please. It's not designed to hold anything up. It's to seek further information to support their case when it's being put forward to panel. They are very empathetic approaches in terms of if we can get more information in this particular area, we might be able to assist you further. And that's what those requests for information are. And there have been occasions, and unfortunately it does mean the case takes longer, where there maybe have been 2 or 3 requests for further information, but they are well-meaning and well-intended to ensure that those cases have the best information possible for a positive outcome.
If we could turn the page, please, to page 60, we again have a chart of the average days from starting a legal case assessment to the RFI request. Again, very much the same trend that we see a peak towards the end of 2022 and possibly a peak again starting in 2024. Once again, I think your answer will be that those will be cut down because of the £75,000 offer. Is that correct?
It would be, if I may add something, if it's helpful to the inquiry.
Yes.
In terms of the full colour of the picture, and again, please, this is not being viewed as defensive. Please don't take this as defensive. It's just the process that happens. Is then RFI, you're going out to the postmaster, and you're going, or indeed their legal representatives, to request further information. The whole process at that point is sort of out of your hands because you need that information to come back to help that case. So we are relying on that turnaround. And for good reasons, really good reasons, sometimes that's not instantaneous. And therefore that you have to build that lag into. And sometimes we do have a process of chasing down and it's wrong to call it chasing. Following up is a better term. Following up those requests for more information. And that's all part of the process. But what it does is, in the words that you use, and I'm happy to use those words, it creates a delay.
Thank you. If we go over the page, please, we can see analysis of the average number of RFIs per case and also average number of days from starting an RFI to the final RFI response. We see at the top there, if we scroll up, thank you, an increase in a gradual increase in the number of RFIs that are requested. Is that correct?
Yes.
Can you assist us with why that is?
I think that will be down to complexity, in that as the easier cases go through quicker, if there is an easy case, I don't think there is, the less complex cases go through quicker. And therefore, the more complex cases, because of their very nature, and therefore the likelihood of more RFIs is more prevalent.
If we look at the bottom table, please, we can see a growing number of days spent on the RFI process. And as recently as the second quarter of 2024, the average time is nearly 120 calendar days. That's a problem, isn't it?
Yes, and any delay is a problem. I think these figures will also include the cases that are in dispute, and they naturally do take longer. And many of those, as I said, in the dispute resolution process, are actually in the hands of legal advisors as well, and that adds a dynamic in terms of their caseload as well. Conscious that they have many clients as well.
But what we have there is, of all the years that this scheme has been operating, the current year actually has the highest number of days that are being spent on that RFI process.
I think that may be down to that factor, because a number of cases are in the dispute resolution process, and therefore the time it takes for the engagement on RFI and the return of RFI is more.
Can you assist us with what you mean by that in a little more detail?
So there are circa, I think, 350 odd cases in that dispute resolution process. They are more intense because the offer has been rejected, and therefore those postal and their legal advisors are suggesting that there's more significant redress needs to be paid. In order to justify that, in order to understand that better, Post Office will be asking for further information.
Why is it particularly in this year? Why is the average time particularly high this year?
Because the other normal cases, the non-disputed cases, are less, and we've got a more efficient process around those. And again, in the RFI process, it will be in HSF, or not at all if it's under 75,000. Whereas in the dispute process, it's still under that process, and therefore requests for information are required. And
in your view, looking forward, how can you avoid that increasing yet further?
The 75,000, again, I know we're going to get onto it, will help massively in that space, because we know a number of dispute cases will be able to be resolved with the £75,000 offer. So that will help enormously. But we absolutely need to get better and more efficient, and we are doing in that space.
So in the dispute resolution stage, can you assist us with what kind of proportion are actually claiming for less than 75,000?
I think the numbers might have been in my statement, but I think there are initially, we know the number that I've got in my head is 25% of cases could well be impacted positively by the 75,000. But that is a determination to be had by the postmaster and indeed their legal representative.
Thank you. If we could turn back to our survey at EXPG 607. It's page 60, please. Thank you. Page 60, figure 45. we have there the third bar is the time it took for the case assessor to assess your claim. Net dissatisfaction, 57%. 40% are very dissatisfied with the time it took for the case assessor to assess the claim. Does that surprise you?
No,
And why do you think that is?
because it's not good enough.
Moving then to the independent panel assessment stage, could we please bring up onto screen poll 00448-026? These are the terms of reference for the shortfall scheme independent advisory panel. I'll just take you through briefly just to explain the background to this. We have at A1, the task of the panel is to assess and recommend to Post Office a fair outcome for eligible claims made to the scheme for shortfall losses and consequential losses. If we scroll down, it has there the panel's membership, and that comprises of legal specialists, forensic accounting specialists, and retail specialists, and it sets out below those who are involved. If we scroll down further to page 3, please, there's a section on general principles. At 31, it says, in formulating its recommended offer, the panel may recommend the making of an offer to the postmaster if, guided by broad considerations of fairness, the panel considers that doing so would produce a fair result in all the circumstances of the particular case. For the avoidance of doubt in doing so, the panel's discretion will not be confined solely to the specific heads of consequential loss claimed by the postmaster, but will take into account any facts or matters which the panel considers will produce a fair result on the facts of a particular case. Have you known the panel to make a recommendation that includes heads of loss that haven't been claimed by sub-postmasters?
I have known many cases where that clause 31 has been proactively used. I can't say with certainty whether that means a new heads of loss, but I have known that they, as part of the process, is once they've opined, made their recommendation, they step back and they look at two things: consistency with other outcomes and fairness. And I have seen them use that license to say, right, to be fair, we believe we need to adjust here, here, and here. I also know that once Post Office have signed those recommendations off and the offer letter is produced, the offer letter goes back to the panel for sanction, and they take another moment then to assess the fairness of that offer.
Thank you. If we scroll down, there's a section on horizon shortfalls, and it says where there's evidence that a shortfall in question existed and was paid, and there is no evidence that a shortfall was caused by something other than a potential issue with Horizon, for the purpose of the scheme, the presumption is the shortfall is a Horizon shortfall. I think that's what you've already addressed.
Thank you.
Consequential loss claims, the panel should apply the scheme consequential loss principles and guidance which are included at Appendix 1. In relation to personal injury claims, where insufficient evidence has been provided for a claim to succeed without further medical and/or expert evidence, the panel may recommend the making of an offer to the postmaster which the panel considers fair. The postmaster will then have the option of either accepting that offer or obtaining such further evidence and pursuing a personal injury claim in accordance with the ordinary legal standards relevant to such claims, including as to proof of causation and assessment of damages. So it may be that the panel itself makes a recommendation in respect of the personal injury aspect of an application. To understand your statement correctly, am I right to say that the recommendation that's made by the panel doesn't need to be accepted by the Post Office?
I have not known a case where it has not been accepted.
But am I right to say that technically it's only a recommendation, doesn't have to be accepted?
Correct.
Yes. And as you say, you've never made it.
I think we've increased a couple.
You've never made an offer, so far as you're aware, that is less than the offer that is
Never.
recommended. On how many occasions, as far as you're aware, has the panel revised their recommendation on that second look that you've already explained?
I don't know, but I know the process does take place, but I don't know how many times they've taken the opportunity to revise it.
Thank you. And what is your role in respect to the panel? Do you attend their meetings? Are you able to contribute, observe?
Absolutely not. They're completely independent. I have no right of attendance to any of their meetings. They are independent. If I had any engagement with them, I could understand the optics of that. So absolutely not. The only time I've met the panel was when they presented to the advisory board.
Thank you. And how about in respect of the Department for Business and Trade? Do you know what interaction they have with the panel?
They have no interaction at all.
Thank you. Could we go back to your witness statement? That's sixth witness statement, WITN 09890600. It's page 62. We're now looking at the situation at the independent panel assessment stage. Page 62, you set out the average number of days from the last RFI applicant response to it being sent to the panel. Thank you. It's page 62. And if we scroll down slightly, we can see that chart. Averaging, I think, 150 days from the last RFI response to be sent to the panel in the last section before we get to the right-hand side. Can you assist us with what the shading means on the right-hand side at all?
I'm afraid I can't.
No?
I don't know why it's shaded.
So it may be that those are accurate figures
I think they are.
for the fourth quarter. And in that case, we are now averaging almost, 700 calendar days between RFI application response and it being sent to the panel. Are those three bars on the right-hand side showing quite a problematic picture as far as the current situation is concerned?
Correct, and that's why we are addressing that.
And is that again the £75,000 offer or something else?
It is the £75,000 offer, and so some cases have been waiting for that to be activated, and therefore they will flow through accordingly. And I think the other one is that let's take a step back and see where we were with HSS as we moved into 2023. We were across 2023, we were effectively winding down the scheme because all we were doing was the later applications. So until the Bates drama came out, there was no peak. So we were downsizing, and indeed HSF were downsizing as well. Then the drama happened, and then the volume started coming in again. So we've effectively had to recreate the business once again in order to deal with the volumes. Now, it will be the 75,000 will help enormously in terms of that, but that has meant a knock-on effect. And one of the things that we have done is we've, in the month of September, we made sure that the panel now sits twice a week rather than once a week, and that will be moving into 3 times a week shortly.
Yes, I was going to address that. So there are about 1,500 applicants yet to receive an offer, is that correct?
Yeah, that's right. Yeah.
Yes. I'll be taking you to some correspondence with Hudgell solicitors shortly.
Yeah.
But in that letter, you say that panel sessions recently increased from 1 per week to 2 per week, and that's 5 to 10 cases per session. Doing the maths, to get through those 1,500 applications, it's going to take more than a year, considerably more than a year, just to get to the panel stage for those applications. Is that right?
No, that's wrong because, and it's the overall picture that now we need to look at. There are 1,500 cases yet to, but the vast majority of those are going to be impacted by the 75,000. So the number is actually going to be a lot less. So that will bring that 10 per week, bring that in significantly. Correct.
Do you think, and as I say, we'll get to the 75,000, but do you think you're putting a few too many eggs in one basket in terms of that 75,000 offer?
The postmaster will have the choice about whether they're prepared to accept the 75,000 or they go for a full assessment. My statement makes it clear on several occasions that the average payout redress for the HSS is £53,000. I sit here as a layman and I look at the average of £53,000 redress versus an increase in that, an offer of 75,000 and a slick, efficient, automated process. I sit here as a layman and look at that logically, and we've looked at our data in terms of the numbers of claims that actually are under 75,000, and they are the vast majority. Now, there is some mathematics and there is some logic in coming to the conclusion, therefore, that we believe the £75,000 offer will make a significant impact in terms of the operationalisation and the time of this process.
We'll get in due course to a number of issues, one of them being that there's potential for an appeals mechanism. So it's not entirely clear that those figures that settled for lower than that sum actually might not in due course seek to appeal the figures that they accepted. We'll also in due course see issues with legal representation.
Good.
And a high number of those that are accepted at that early stage not having legal representation. In light of those problems, those potential issues, might it not be that actually that 50,000 or so figure is wrong, and that actually ultimately people seek more than 75,000?
I think that's a potential, yes.
And won't that throw a slight spanner in the works when it comes to the predictions that you have for alleviating those problems that are imminent?
I think you can separate the two between an appeals process and between the applications that you're going to get in under £75,000.
What do you mean by that?
I think the potential appeals process, it's been announced, but there's no process behind it yet. That will deal with any case independently in government with anybody who wants to appeal. And they're not prepared to take the 75,000, that's absolutely fine. And if they're not prepared to take the 75 and an offer, then that will go through the full process. And I think the numbers that we anticipate in that we can cope with. I still believe that our anticipation is that a significant number of claims will come in for under 75,000, which will be able to process quickly without a legal review.
But
I hope
that anticipation is based on previous figures.
Yes.
Previous figures which themselves may no longer be accurate because people are going to seek to challenge those figures.
They may do that. I repeat my statement, and I recognise that only 10 to 12% are legally represented. I really do, and please, this is not defensive at all, but 83% accept their offer.
And do you read into that 83% are content with their offer?
I have to draw some conclusion to that. But I know what the legal advisors will say. You know, they're not well informed enough. Except I absolutely get that as well. But they have made a conscious decision to accept that. So I have to read something into that. And the appeals process, when it comes, will give them the opportunity to say, well, actually, I wasn't sure what I was signing at the time, and therefore I do feel this is unfair, and therefore I want to launch it. And great, that is fantastic. But they also might say, actually, it is that I don't believe that was fair, but the 75,000 is now fair.
Have you planned for a scenario where, in fact, not as many people take up that £75,000 offer as you currently expect?
I have to. Yes.
And how are you going to deal with that when we see figures like this? The process, the RFI process, the case assessment process, taking a considerable number of days.
We have to be more efficient, and as the interim chair actually made it very, very clear, we'll have to automate more and be more efficient, and indeed, for example, introduce the SFI process much more aggressively into that population.
Thank you. You've said at paragraph 88 of your statement, we don't need to get it up. On average, it takes 37 days from the panel assessment, panel recommendation to the offer being sent. Could we please turn back to our expert report from YouGov, EXPG 607, page 62. Page 62. If we scroll down, we can see their satisfaction figures in respect of the information provided by the Independent Appeals Panel and the length of time to consider the claim. Again, a lot more red than there is purple. Net dissatisfaction with how long it took for the IAP to consider the claim, 46%. Amount of information provided about the IAP process, 52% net dissatisfied. Do you have any views on those figures and why that might be?
I'll repeat myself. It's just not good enough, and I apologise on behalf of Post Office and in terms of the process that it takes so long. I do believe we get full and fair outcomes out of it. And as Sir Wynne has mentioned more than once on previous witness statements, it's the timeliness which is the issue. And the Post Office apologised for the time it's taken, and it has taken too long. Am I surprised by these? Absolutely not. Am I doing something about it? Yes.
Thank you. The next stage is the Post Office review. That can come down off the screen, please. And that's when the Post Office reviews a recommendation of the IAP. Can you assist us with who at the Post Office reviews those recommendations?
Of the independent panel?
Yes.
We are told who it's going to be.
You receive them, though. There must be some internal discussion.
The names are put forward by HSF, and the names are circulated for interest. But we don't opine about whether we're supportive of that appointment or not.
Sorry, I mean in terms of the actual recommendation in individual cases that's made by the
apologies. Who sees those recommendations?
Yes, and who is involved in any kind of internal analysis or assessment of those recommendations?
There's no assessment of the recommendations. They are what they are. There's no challenge to those recommendations. It's me. I chair a committee that look at all recommendations that come out of the independent panel, and we understand how the panel have come to those recommendations and sanction them.
Once the recommendation is made and accepted, does the Post Office ever revisit those figures? Even to increase them once the offer has been accepted?
Where there may be, the answer is yes. Where, for example, where we may have introduced a new heads of loss, we may have adjusted a principle or adjusted a heads of loss because of a new case that has got a nuance in it that hasn't been considered before. Then actually we don't put anything on hold, but we realise that actually that might impact previous cases. So we do a backward review with the panel's assistance. We do a backward review on all cases that might now have this additional nuance in it, and we adjust.
Approximately how many times have you had that backward review process?
I don't know, but we've definitely had one. but there is the opportunity there for. I'm sure it's more than one, but I can only recall one.
And in that one, was there a revisiting of earlier acceptances and communication made with those postmasters?
Correct.
Thank you. If we go back again to the expert report, EXPG 607, I think this is the final time that I'll take you to that report, page 63. Thank you. Page 63 has the satisfaction with the amount of information provided and how the application outcome was determined. If we scroll down, we can see in terms of the time it took, 52% net dissatisfied. The offer amount, 59% dissatisfied. The amount of information provided to you about how the outcome was determined, 49% net dissatisfied. If we go over the page, onto page 65, please, there's figure 49. Reasons why applicants were accepted, the offer in part or full, and we only have a figure of 15% who say that they accepted because they were satisfied with the offer. What's your view of those figures?
Obviously, extremely disappointed. I think where I struggle, and I know it's simply an optic, and it's simply numbers on a piece of paper, and I need to talk about numbers on a piece of paper, please, if it helps the inquiry, is that the 15% satisfied, it doesn't tally in my mind with the 83% acceptance rate. That's where I struggle. But what concerns me more around these, and I looked at these numbers in particular, what concerns me more about this page is that the process just to finish is 51. That really concerns me. And that goes to what some legal advisors have been saying to me as well, that people just want this done, and therefore whatever you put in front of them, they're going to sign because they just want to walk away from it now. It's taking too long, it's too legalistic, etc. You're putting too many barriers in. So that does concern me. On the more optimistic side, what I'm hoping is that the new appeals process, when it's ready, hopefully in the new year, will be able to accommodate those people to say, right, I wanted to finish, but now I've got the appeals process. I wasn't satisfied with that. I wanted it to finish, but I wasn't. I can now apply to that.
Thank you. That can come down. I'm going to move on to the dispute resolution process. I'll introduce that briefly before we break for lunch, but we'll have to return to it after lunch. The dispute resolution procedure applies if the offer is not accepted by the postmaster. Is that correct?
Correct.
It's assigned to a case manager. Can you assist us with who a case manager is?
It'll be a member of my team who has a broad knowledge of post office and how it operates, but specifically around how to deal with disputes. And the team is currently 23 people, and they all have their own portfolio of cases.
There's then a good faith meeting, and the next level is what's known as an escalation meeting. Okay. Is that correct?
So there are four layers of dispute resolution process, all determined actually by the GLO settlement in terms of when the HSS was established. It was agreed that a dispute resolution process would be established, and therefore it's pretty within given terms that we had to create a four-layer dispute process. So good faith, escalation, mediation, arbitration.
Thank you. In terms of a good faith meeting, can that result in an increased offer from the post office?
Sometimes, yes.
And has it resulted?
Yes.
After the good faith meeting or the escalation meeting, it can then go back to the panel, can it? Is that
it can,
correct?
Yes.
Is there a maximum number of times that it can go back to the panel?
No.
Is that set out anywhere in any of the terms of reference or guidance in respect of the process of it going back to the panel and how often that can happen?
Only going back to panel only internally, into say the process is once we think we've gathered enough information that may change the view, then it goes back to a panel. But as as no doubt you've picked up from recent correspondence with Dr. Hudgell, is that we are now adjusting that to say if the legal representative or the postmaster actually don't want it to go back to panel, and would prefer Post Office to take a commercial view on that, then that's fine as well. We know we're beholden to what the postmaster and what their legal representatives preferred option. There's no set plan. It has to go back to panel if that's the question you're asking.
And then finally, you have the formal mediation with Wandsworth
Yes.
Mediation Service. Does that take place? Has that taken place?
Yeah, it's taken place quite a few times, and so far successful in every occasion it's been used, and some positive feedback on it as well.
I'm going to return to this topic after lunch, but that's an appropriate moment to take our lunch.
Yep.
Thank you, sir. At 2 o'clock, please.
Yep, sure.